vis-a-vis the responses of the nominee himself. Just about now, I see the chairperson of the committee make a comeback into the vetting room. Indeed, what it is expected is that pretty shortly after that, and per the time given, the 20 minutes given, we are just left with about 4 minutes, which means that just around 5:10 p.m. the session should be back in action. But you would recall that we've had a trajectory over the period since this nomination, somewhere earlier in April this year. The minority has always had a stance. They've always had this stance that when you look at, the work of the Parliament Committee, which today the leaders sought to address, it has not been that which they believe followed due process. And so they've always, spoken about that. And even last week, in fact, a number of press conferences have been held in which they have sought to address this issue. Even today, after they had walked out of the vetting room, they addressed the press and reiterated the point again that, see, there are about 6 active cases of the Chief Justice, the former Gertrude Sabato Kodu, which are pending when you go to the High Court. A number of them, one that I would say is my favorite, which she makes the case that if she has been removed as the Chief Justice, she should still be given that chance to serve on the Supreme Court bench. One which really, and as lawyers will tell you, would require some constitutional interpretation, and which means that at all costs, that case should be transferred or transmitted from the High Court to the Supreme Court. And then there are other ones as well challenging the processes that led to her removal. And she is also at the ECOWAS court. Right after walking out of the vetting process, they held that presser in which Kwame Anyimadu-Antwi, who is one of the sponsors of a motion that was sent to the Speaker asking that this vetting be not held, addressed the press again to make that case yet again that.
Right, so that's Christian Yali, who is our parliamentary correspondent, updating us on what exactly has gone on. And many of you have been following, including our guest who's also joined us on Zoom. He's been with us right from the inception, and I'm sure that Professor David Abdullahi has also been following after the long back and forth between the minority and the majority leader. Finally, the vetting has commenced, what we're all looking forward to. And the justice nominee, I beg your pardon, the Chief Justice nominee has actually started answering some questions. And I want to take the preliminary thoughts of Professor David Abdullahi, who is a governance expert, and he's with us. Prof, thank you for staying with us right through the beginning up until now. What would your initial thoughts be about some of the questions that have been posed and the answers that have also been given as a result of those questions?
Thank you very much. First, I'm very impressed with the way he answered questions and also his thought process of what he intends to do if he is given the nod. I also think it's not just the idea of what he's going to do, the thought process of bringing innovation into the current judicial process, employing artificial intelligence, moving towards a 24-hour court, and so on and so forth. I think this is the right direction because we're in a new era where technology is very important in the dispensation of justice. And if he can, or if he's given the nod and he can be able to introduce all these things, it will bring some sanity into the process and making sure that most of the backlogs and all the suggestions he will bring into fore will work. And I also think he has the temperament. If you can see how he speaks, he has the temperament and also, the confidence based upon experience and the fact that he rose from the lower ranks up to where he is now in the judiciary to be able to deliver what he's looking at to bring forth. Yes.
Yeah, it's interesting that two things that he said that stood with me, or that are still frontal, that I would want us to talk about. One has to do with the backlog which he complained about, and then empaneling judges for, specific cases. And just by way of a reminder to our viewers, we are also simulcasting this broadcast. So we are also on 3FM 92.7. So in case you are just about leaving, or you can tune in and continue listening to this conversation and the vetting as well. In a few minutes, the vetting will continue, or of course we can see on your screens that the committee is getting back to their chair, and then also we are expecting the nominee to also take his chair so that the vetting continues. But Prof, talk to us about this major concern where he says that in Sawam prison, which is one of the most popular prisons we have in the country, was built to accommodate just about 851, but as of today they are having in excess of over 3,000 individuals, fellow human beings, locked up in there, and has made proposals or suggestions as to how we can gradually, decongest the prison. What do you make of some of the proposals he's making? He's talking about AI, and probably some people have been given bail but cannot meet the conditions, and a number of issues he thinks that are the challenge, but we need solutions to it. What did you make of his answer to that?
But he didn't only talk about in Sawan, he also talked about Kumasi, yes. and So I think, apart from the suggestions he has made, I think the government needs to help in being able to build, expand the prisons. I mean, build more infrastructure. Now, the infrastructure will support the technology that is going to be employed to be able to make sure that that happens. And apart from that, I think what is also important is it's not just only the technology. You must have, the data and the statistics to make sure that you know who is where and what time and when they were actually sent to prison and what should happen. But for the suggestions she's made, I think they are very spot on. The most important thing is not just saying it. We just hope when he gets in, he has the opportunity to be able to leave an imprint and bring about solutions that would move the process forward, knowing that if he's approved, he doesn't have so much time left before he goes on retirement. Apart from that, I think all what he has said, I agree. But let's just also talk about the fact that you cannot build a prison during that time, and now we are in an era where the population has grown and you didn't build infrastructure. The government should be held responsible, or they should listen to that particular point and be able to do the needful.
Yeah, and that actually ties into another point he made about the fact that now a lot of Ghanaians are quite interested in running to court with the least issue. They want to go to court for settlement, and that is one of the reasons why there seems to be a backlog of cases at our courts. Well, Prof, kindly hold on for me, or stay with us. We are going back to join the feed to continue with the vetting.
Okay.
You are entitled to 3 questions.
Thank you, Chairman. My Lord, congratulations.
Thank you very much.
3FM 92.7.
Thank you. My Lord, your nomination as Chief Justice marks not just seniority, but a symbolic restoration of trust, tradition, and constitutional renewal or resetting. Now, the question I have for you from the above opinion is, what specific reforms will you implement to restore credibility and revive the judicial sinking image?
Thank you, Honorable Chair. I think the image of the judicial service has gone down. A lot of people have a lot of problems with the service, particularly with regard to the fact that
cases keep so long in court. People go to court hoping their cases hoping their case will be heard within a very short period. And cases, but there are some now. The average number of years that a simple civil case can stay in court is about 3 years or 4 years. There are some cases that have been in court for so long. There are also criminal cases, as I said earlier, where people are facing trial over a long period. All these affects people's confidence and trust in the service. But as I said earlier, some of them can be tackled because they are institutional problems. Like, we have vacancies for as many as 116 magistrates. We need to fill 116 courts. We don't have personnel. There are some courts that do not have infrastructure. I mean, you go to the courts and then the buildings are in very serious states of dilapidation. I remember last year, over the past 3 years, the District Assembly Common Fund sponsored the building of about 100 courts together with their residences. But it's still not enough. We still have some of these courts built but not occupied because we don't have the personnel. But that is not to also mean that we should throw our hands in despair and say that we can't do anything about it. Admittedly, there are some cases that do not move fast as a result of, as I said earlier, the technicalities associated with our rules and other things. But we also recognize the fact that there are some judges and magistrates who do not put up their best. And all these add to the creation of backlogs. And I also mentioned earlier that people are now too eager to go to court. And so we want to, as we want to build courts to take care of the more cases that are coming up, that we also want to encourage ADR. I was at the ADR week in Koforidua, and the reports that they gave us that of about 600 cases that came, about 470 or about 480 they were able to solve them through ADR. And so we realized that if they aim, but it is still not, people still do not know so much about the ADR. So if people are sensitized enough about ADR, they will embrace it and then leave the courts for more serious matters. The way it is that there are some people who, no matter what, who want to go to the regular courts. They want to have their pound of flesh. But so it's a combination of a lot of things that lead to this backlog of cases, and that is what people's confidence or trust in the judiciary going down is more as a result of the fact that their cases are not heard early. There are some people who also have lost confidence in the judiciary because they say that judiciary is corrupt. How they come by that decision, that statement that judiciary is corrupt, I have made mention of the fact that the judiciary is as corrupt as the people who man it, and the people who man it are as corrupt as the ordinary Ghanaian. The ordinary Ghanaian goes to the bank and he is told that give your money to the teller, otherwise you may have your money stolen. He goes, and instead of being in a queue for just 2 minutes, he sees somebody sitting down there, or somebody recognizes him and says, "Oh, I'm a teller," and then he takes his money to go and deposit for him. Before he's aware, the man has stolen his money. The ordinary Ghanaian goes to the courts, and I tell you, if 100 people evince the intention that they are going to see a judge because they have a case in the court, less than 3 of them will be able to go to the judge personally. They will go through his girlfriend, they will go through his wife, they will go through his friend, they will go through all kinds of people. So anybody who they think is close to the judge is game. You go and give your money to a court clerk or anybody. There are some people actually waiting around the courts who the court clerks, they know them. We have people we call bail contractors. All kinds of people patrol the courts. So you want to see why you want to see a judge because you have a case there, only you know. And then you cannot go and see the judge because you are afraid. Then somebody tells you, "Oh, that I saw the judge talking to that lady. So it is his sister, it is his daughter, it is his girlfriend. So go and see her." So people give their money to people, and then they don't, once they have given the money out, they have bribed the judge. They have given, they are okay. So such people go about saying that, "Oh, the judges have taken their money." And once the judge has taken their money and they get their judgment, they are okay.
2.7.
While the judge has taken their money, they lose their case, and then that's when they start talking. So that is not to say that there are no bad nuts among us. There are. But these are the reasons why people's confidence in the judiciary is sinking. And I intend to, once we know the causes of the decline in there, then we can tackle it. So if we sensitize people about ADR, that it's not every case that should go to court, mainstream court, and we sensitize people about ADR, people will go there. The backlog will reduce. If we review the rules, as I suggested earlier, it will affect even the trajectory and the speed at which cases are heard, and it will improve. And if, as I said, since there are still some bad nuts, if we catch the bad nuts and they are disciplined, then it will serve as a deterrent to people, to other judges. So we are going to, as it were, reinforce the disparate measures. The Judicial Council is going to take up this up because we already have a complaint unit, but people don't even complain there any longer because sometimes they feel that they have complained and they don't get good responses. I'm going to reignite the whole to reinforce it so that, because we should get, the judiciary should be able to get the confidence of the people back. Otherwise, we might end up having people say that, well, I'm not going to court, I'm going to do what we call mob injustice. Thank you.
Any further question?
Thank you. Having listened to you, I want to find out, will you reinstate the electronic case assignment, which was introduced to keep judge shopping and later discontinued by your predecessor?
I think I am all for it. I am all for it. It is going to be reintroduced. I think about 2 or 3 years now, we have a situation where applications that are filed do not have return days. You go there, they say date to be fixed. Immediately so we found there were situations where a case comes before us, an application, even before the Supreme Court, an application comes before the Supreme Court, and we realize it is virtually moot because the application, which was actually time-bound, had date to be fixed on it, and it has been fixed for the past 2 years.
92.7.
So immediately I said that one was wrong. So every case that is filed, every application that is filed should be brought to my attention so that we fix, because most applications are time-bound. And so I did that for some time. And now things have stabilized. So we don't have dates to be fixed again. We now have dates given to applications that are fixed for hearing. So with substantive cases, we are going to reintroduce it used to be there until the machines broke down, the system went off, and then it was allowed to fall into abeyance. Now we have actually started doing the electronic.
Thank you very much, Honorable Umar. Do you want to ask your last question? Yes, please do.
Thank you, Chairman. My Lord, there are persistent concerns out there that the current process of appointing judges and chief justices give excessive influence to the executives. What reforms, if any, would you recommend to make the appointment process more transparent?
Thank you, Madam Chair. I think I'm the wrongest person to ask this question because, as I said, I have had my elevations across political divides. But I think the current system, for us, it follows the Constitution. If the Constitution is going to be amended to give us a different mode of appointment, then that's it. But the current system with Superior Court judges up to Court of Appeal, they are appointed by the Judicial Council, by the President, in consultation with the Council of State on the advice of the Judicial Council. And the Judicial Council is made up of persons, apart from 4 nominees of the presidency. We have the JUSAG represented, we have the lower bench represented, we have a High Court representative, Court of Appeal representative, the Supreme Court representative. We have institutional representatives like representation from, let's say, the police, the army. These are all members who come from different backgrounds, and they have contributions to make. And they advise the nomination or the nomination appointment of members of the court up to the Court of Appeal.
3FM.
So, and when it comes to even selection of nominees for the president to appoint, we have persons who are mentioned by the Attorney General, who is a government person. And then we have the Chief Justice also bringing nominees. And then we have the Ghana Bar Association also bringing nominees. So what happens is that there is a list produced by these 3 groups. The Chief Justice normally bases his or her nominations on seniority at the bench, performance, and other things. Maybe if a person has disparate proceedings against him, that's a different matter. Then the Attorney General also nominates, and then the Bar Association have the chance to nominate persons from the bar and also from the bench. The idea is that the bench, our performance is also always reviewed by the lawyers, by the bar. So we have a situation where when these 3 lists are produced, you find a particular, let's say we want an appointment to the High Court. You will find a particular circuit court judge whose name appears in the list of the Chief Justice, in the list of the bar, and in the list of the Attorney General, because the bar is the beneficiary of the efforts of the judges.
3FM,
so the judges make recommendations. In the same way, when lawyers appear before us, we know those who are good and those who are bad. And we also know those who have the temperament and the demeanor and everything that can make them judges. It's not every good lawyer who can be a judge. So sometimes we on our own. I have mentored so many lawyers, and I'll tell you, I can tell you that you will be a good material. So apply to join the bench. So even though the Chief Justice normally nominates from the people from the bench, the Chief Justice could also nominate somebody from the bar. So when these nominations are done, it go to the presidency, and then even though the wording is that it is done on the advice of the Judicial Council, and the Supreme Court has said that the Judicial Council's advice doesn't bind the president. Nevertheless, I have been a member of the Judicial Council, and currently I am its chair, acting chair. If 40 people are go through our net at the Judicial Council, less than one or a maximum of two may not be taken by the presidency. So the advice, we say it doesn't bind them, but in reality they listen to us because the president knows that it is the Chief Justice and the Attorney General who deal with these people. So if they make this advice, and so with this kind of nomination from these three people, how people can talk about political, I can't really understand. With the Chief Justice, the Chief Justice, over the years, this is how it has been done. It is I think, well, I know in Kenya, things are done differently. The Judicial Council or Judicial Commission is very empowered. But whatever it is, the president has a say. And at least that is what our constitution says. If Ghanaians believe that the constitution should be changed to give power to other persons, other bodies to nominate their Chief Justice or the President, Supreme Court judges, then they can lobby the Parliament for honorable members to have a look at it.
Thank you. Honorable members, on this note, we will then proceed to take questions from members of the subject matter committee in line with Order 217. Honorable members, subject matter committee members can ask 3 questions, but they are only entitled to 2 supplementary, if any. So, Honorable Bede Asiedu, you have the floor.
3FM 92.
The name is Bede Asiedu.
Thank you very much, Mr. Chair. I was going to correct it because you are putting the wrong name to go into the Hansard, and I object to that. Anyway, thank you very much for the opportunity. My Lord, congratulations for this nomination. And I think that you deserve this nomination. You have served this country for such a long time, and I believe that what is happening today is the icing of the cake. And
thank you very much.
We will proceed to ensure that you enjoy this cake. Let me also use the opportunity to thank you for the guidance that you provided me whilst I was in practice. I appeared before you a couple of times, and I think that I was impressed with the way and manner you guided me throughout. I didn't stay there for long and came out to my political field. But I appreciate what I got. Thank you very much, my Lord. My Lord, I have a few questions, and I will send you back to the issue of the appointment of judges to the bench. And as you have already stated, this has been provided for under Article 44 of the Constitution. And that provision gives the President the power to nominate and appoint justices of the High Court, Court of Appeal, Supreme Court. Yes, there are certain processes that go through, but ultimately, it is the President that we see. That's what the Constitution has provided for. He does the nomination and he does the appointment as part of all that. We have tried to explain that even though
Honorable, you are violating our rules. Please ask question.
I'm asking the question. I'm laying the. My mic is. My Lord, I want to find out from you. Do you agree with the current arrangement in terms of the appointment of judges to the High Court, Court of Appeal, the Supreme Court, the current arrangement as provided under the Constitution? Or do you think that we can have some other arrangement? And if we can have some other arrangement, what type of arrangement should it be? Thank you, my Lord.
I do. You asked me whether I think the current arrangement is okay or it should be adjusted. I think that the current arrangement in football, we say if it isn't broken, you fix it only when it's broken. The current arrangement has served us well from 1992 till now. It's not broken. You shouldn't fix it. I believe that the current arrangement, you see, the Constitution, as we have always said, must be read in such a way. You should read every phrase and every sentence, every word in the Constitution. And then, if you look at the practice, as I said, as you rightly said, the nomination and appointment and everything is done by the president. But I have told you what goes on in reality. And in reality, the Judicial Council plays a very crucial role. We advise, the Attorney General has a role to play, the Bar Association has a role to play. And so you may not have this laid down in the Constitution, but in practice, this is what goes on. And that's why I'm saying that, as far as I'm concerned, I'm comfortable with the current arrangement of appointing judges. And that is how I see it.
Thank you. Before allowing you to proceed with your second question, I want to remind all of us about Standing Order 88.7, and I read, a member in asking a question shall not address the House, raise any argument, or offer an opinion. So let's keep to these rules, and then we can make progress. Now, your second question, if any.
Mr. Chairman, I have a supplementary question.
Yes?
My Lord, my supplementary question is that,
3FM 92.
having heard you, and you are convinced about your position, how do we remove the suspicion or allegation that some presidents try to pack the course? How do we remove that one? Even though people go through all these processes, and yet the allegation is that
you are violating the rules that I've just read. So please, my Lord, your answer to the supplementary question.
People suspect that in the first place, what is packing the courts? Are we talking about the number of persons appointed to the court or what? Yes. I don't know how people's suspicions can be dealt with, but as far as I'm concerned, as I said, persons have been promoted on the advice of the Judicial Council. If 40 people, names of the current lists on the advice of the Judicial Council, 41 persons' names were sent to the presidency, and only 4 out of the 41 names were taken out, and even only on the grounds that they had not finished with the background check, as at the time they were because I was sitting on the, I was pleading with the president that we needed to have these people sworn in so that the legal year the legal year could begin with the courts full. But the president, they had not finished with the national security clearance for all of them. In the long run, out of 41, recommended by the Judicial Council, made up of members of the bar, members of the judiciary, members of the Attorney General's representative. These 37 out of the 41 names were sent to the presidency, and only 4 were not taken. If anybody sits outside and says that the president has packed the court, how will I be able to convince such a person that it's not the president actually who put the 37 people there? We did. He only took our advice. So it is not as if people's suspicions are going about that. You cannot go about trying to assuage people. You can't do that. People will still have their suspicions. One of the questions that I got was, people are saying I got my nomination as a result of 2013. I have explained my way. If people still have that feeling, can I do anything about it?
Thank you very much. Yes.
I'm bringing the question, Mr. Chairman.
Please ask question. I've just read the rules to you. You can address us.
Very well. Simply, what reforms are you going to bring to the table outside the reforms that you have already mentioned? Because you have already indicated some reforms that you are going to do. What other specific reforms are you going to bring to the table in terms of accountability, professionalism, etc., etc.? Thank you.
The Judicial Service mandate is to adjudicate cases and then ensure that the laws, the Supreme Court will interpret the laws, and all these come as a result of adjudication.
92.7.
As I said earlier, and we all agree that one of the problems that we are having now, the crisis, is as a result of people losing confidence in the judiciary. And we have traced it to certain happenings, like, as I said, we mentioned the complexities of the rules. We talked about backlog of cases and all that. One of the things that that is there, but it is not really nationwide, is the e-justice system. The e-justice has been introduced. It's been going on for some time now, but it looks like the e-justice, which is supposed to help us in so many ways, is only within Accra, and also even within Accra, it is within the law court complex. It is my hope and ambition that we will have a rollout of the e-justice to all the regional capitals by the time that my term is out, by the end of next year. All all the regional capitals. The aim is to get e-filing, e-justice to all courts in the country. But that is a long-term thing. My aim is to have the e-justice rolled out in all the regional capitals. And that will be something that will help. And then we always talk about justice in terms of cases that come to the court. We don't talk about justice in relation to even the workers. It is very, very, very important to recognize that apart from the judges, the judicial system is not made up of only superior court judges. Superior court judges, by virtue of Article 71, have their salaries decided by the presidency through the committee and then parliament. Whilst the lower bench have their salaries tied to normal civil service, civil servants. And worst of all, the JUSAC, who actually form the bulk of the judicial service. As a matter of fact, if you look at our numbers, the judiciary made up from magistrates to the Chief Justice, we are just about 511. Only 511. Out of that number, those who form the higher echelons, who enjoy Article 70, Article 71, are the High Court of Appeal and the Supreme Court, we are not no more than 230 or something like that. So if you talk about our salaries in terms of Article 71, you are talking about only a fraction of members of the judiciary, judicial service. So we also have to think about reforms that should affect the lower bench in terms of salary, in terms of working conditions, because whilst we struggle, whilst we strive to get accommodation for judges of the Court of Appeal and the Supreme Court, even some of the High Court judges, even in some regions, regional capitals, they don't have accommodation. As for the magistrates and the circuit courts, the least said about them, the better. Because you go to some places and they are renting the most beautiful house. And before you are aware, that most beautiful house belongs to a perennial litigant, perpetual litigant. Somebody is almost always in your court. So you find it impossible to even work. You understand? So we should also be thinking about, whilst we are thinking about clearing the backlog, doing that, we should be thinking also about the staff. And that is what I mean to do. I want to have a proper discussion of the terms and conditions of the terms of engagement of the lower bench and the staff. That is something that I will make my personal project.
Thank you very much. Yes. Any more questions?
That will be all for now. Thank you very much.
2.7.
Well, thank you. You said that will be all for now. I believe you won't have the opportunity to ask questions again. We are now moving to the leadership. And I'll plead with the leadership that the 3 questions rule would apply to us as well. So, Honorable Majority Leader Mama Yariga, you have the floor.
Thank you very much. Let me also congratulate the nominee, Acting Chief Justice, for his nomination to occupy the position substantively. I'm sure you sat through and you listened to the engagements between myself and the minority side. I had no intention of preventing anyone from freely expressing themselves. I just wanted them to do so in accordance with our rules, so that there can be sanity in the way that we conduct business. I think the gravamen of their case, which I would have preferred that they sat here and asked you, because I know you are very capable of providing them with a response, is that they question whether it is proper for you to be taken through the vetting process
92.7.
because there are a number of suits pending challenging the removal of the previous Chief Justice. They are asking what the implications for stability in the judiciary will be, assuming that those challenging the propriety of the removal of the previous Chief Justice succeed in their claim. What will be the nature of the enforcement of the reliefs that they are seeking, and etc. So basically, the question is, do you think that it is proper for us to go through this process whilst these suits are pending?
Thank you, Honorable Chair. I think it is proper. That is the first basic answer. It is very proper. It is a constitutional duty that Parliament is performing, and as at now, there is no order from any court of competent jurisdiction stopping you from performing your constitutional duty. The President has nominated somebody for Parliament to vet the person for the appointment to the position of a Chief Justice. Vetting of the nominee is a constitutional duty imposed by you by the Constitution. A duty imposed on you by the Constitution. So if you have to perform it, nothing, and I think absolutely nothing, stops you from performing your constitutional duty. You see, in the years gone by, when cases like Dufo versus the Bank of Ghana, which I authored, actually, were written, the learning was that, and the practice actually was that when an application for injunction, or when there's an application for injunction is pending, then you hold your hands. So there were situations where persons will rush to court to file a writ or file an application for injunction, and if you go against, even without any order from the court, you went ahead to do what the injunction was being sought for, then you'll be cited for contempt. And cases like Dufo versus Bank of Ghana, Sito and other things came up and said that that was right. But the learning now, particularly after the case of Vincent Asafua versus the Attorney General. I mean, it's an unreported case. It was done fairly recently. The learning now is that if there is a constitutional duty to be performed, until and unless there is an order from a court of competent jurisdiction, no constitutional body is prevented from performing such a duty just because somebody has filed an application for injunction or even a writ. Even the application for injunction may be handled, may be understood, but a writ, when we do not even know when a writ is going to be heard and determined, you can't do that. As a matter of fact, that is constitutional. But let us even look at an analogy. When President Kufuor was declared, President Mahama was declared, and he was sworn in on the 7th of January 2013, it never prevented His Excellency Nana Kufuor from pursuing the petition. He did. It also didn't prevent the president from performing his constitutional duty as a president. He did. These two things went side by side until the 29th of August, when the court said the matter was ended in favor of the sitting president, so he should continue. And he did continue. If the courts had come to the conclusion that it was, the judgment should go the other way, and that the president should step down for Nana Addo to take the seat, that would have been the order of the Supreme Court, and would have been enforced by Article 1 and 2. The same thing would have happened in 2020, when there was this petition. So a constitutional duty that is supposed to be performed, as a matter of fact, some persons are even of the view that even the Supreme Court cannot even come to the Parliament and then make an order to stop a constitutional duty being performed. But that is another matter altogether. But for as long as no order has been made by any court, a constitutional duty will have to can be performed. And I think it is right that we are going ahead with the vetting.
So in essence, there's no court order restraining the president from nominating a Chief Justice, and there's no court order restraining Parliament from processing the nomination of the president.
There's no court order.
And you are here because we have summoned you to come for us to process you.
Which I couldn't refuse to.
Of course, you cannot refuse our summons. You cannot refuse our summons. But the second issue that they raise, and I want to be fair to the records, is that they also say the cases that have been filed, you are sitting now as the acting Chief Justice, and that you haven't listed those cases to be heard. Is that accurate? And why would that be the case?
If this statement is made by,
2.7.
with all due respect, I don't know whether it is parliamentary language.
Yeah, they made it here.
If this statement is made by a person who is not a lawyer, I will put it down to ignorance. I will say that maybe the person is uninformed about legalities, so I will pardon. But if a lawyer makes a statement like this, I would think that it is populist and maybe downright mischievous. The Chief Justice does not list cases, and please, my words, the Chief Justice does not list cases for hearing. The Chief Justice empanels judges to sit on cases that have been listed. Cases are listed when they are ripe for hearing. So we have listing, we have cases getting ripe for hearing and then being listed before the empaneling is done. The Chief Justice comes in after a case is ripe for hearing and it has been listed, and then he empanels. So the Chief Justice cannot be accused of failing to list cases or empanel, when the case is not even ripe for hearing. A case is ripe for hearing when pleadings have closed. Pleadings get closed with it. Pleadings are issuance of a writ, a response, and then even sometimes we ask you to file memorandum of issues, particular constitutional cases. So these three things are done, and when they are done, we say the case is ripe for hearing.
Accra gets busy on this frequency. 92.7 3 FM.
Hello, Ghana. It's a new year and Bills Microcredit is here to support your dreams. If you're not working but want to start a business, don't let money stop you. With just your Ghana card, you can get a loan to turn your ideas into reality. Already running a business? Need more capital? Or are you a salary worker looking for extra funds? Bills offers fast and easy loans with no collateral, no deposit, and no SUSI savings required. Wherever you are, whatever you need, Bills makes it happen. Call Bills Microcredit today. Call 0596 920 833 or 0302 200 390 and get started. Bills is licensed and regulated by the Bank of Ghana. Bills, financing your needs. Terms and conditions apply.
We've got the city moving on 92.7 3 FM Drive with Trigmatic. Your commute just got an upgrade. Let's roll.
Just like church is a cover for so many of you. Church is a cover. This what we have covered our eyes and faces and our heads with the Bible, and we have left the fridge.
Church people, so evil.
It's DJ Fat.
I saw a lie, some things to be necessary. Hope me I could try to stand so be a one shade. Oh Lord of mercy, sinners are judging sin. Oh Christo into nyame sumne. I got whole lot of guts on my mind, to my mama nyame na. Oh no, how mukulu subu pasta. I got whole lot of guts on my mind, to me to him in pasta. Nyame summa be a funti kasi ampani be a timiti asari. Church people, so nyaya, so evil. Church people, so evil. Suffering me excited. A whole lot of mind games them play.